That's the explicit intention that we bring to the work. And it really, I want to be cautious in saying this because I'm not trying to denigrate any other way of helping clients reach resolution. Anything that you can do to help people make their own decisions and avoid conflict is great. But I have not found another way to work that offers so consistently and invites so consistently that the clients move from reactive, emotion-fueled behavior to a more considered and long-looking perspective. Nor do I know of any other approach that so consistently asks clients to identify their own values and the relationships that matter to them as vital pieces of the picture in moving through issues to resolution. I pay attention every now and then when I can to what we call the collaborative listserv, which is a forum for practitioners from every discipline and every level of experience, and geographically from anywhere, to post perceptions, ask questions, ask for input, and sometimes there are some exciting and challenging conversations that go on there. And one that pops up every now and then, which always gets the attention of the more experienced writers and trainers, because there's uniform point of view, as far as I know, among all the people who have been leading the movement, creating standards, writing the books that reflect our best practices, training. There really is no difference of opinion here. The IACP website defines the standards for professionals to call themselves collaborative professionals within the meaning of our movement's international standards. And we have very high standards, and that's good. That's how it should be. We aren't gatekeepers. Our movement isn't, our organization isn't. Nowhere has anybody tried to legislate anything. Nowhere has anybody tried to say you can't join our organization, or you can't come to our meetings, or you can't do whatever it is you do. But that's not the same as saying that somebody without credentials is practicing on an equivalent level of, well, I will say expertise, but really what I mean is offering a kind of a reliable assurance to clients that their training and experience comes up to some kind of a standard. Divorce work is really, really difficult and challenging, and it takes all of the training and experience that we can bring to it to learn to do it well, and we're always learning to do it better. I'm not saying that having a license to practice law, or a license to be a psychologist, or to be a certified public accountant is the only way to know how to do good work in the divorce field. But I don't think you can have meaningful standards without setting out education, licensing, and experiential requirements. And it is an aspirational standard that we lay out that we want people to meet. So to me, it's completely self-defeating for anybody to take the point of view that it doesn't matter. Of course it matters. It matters a lot to clients. If I were going through a divorce, I would not want to be assisted by somebody who was just cutting their teeth in learning how to do divorce work unless I knew it full well and had made an informed choice to go with somebody who didn't have the credentials or experience rather than somebody who did. I don't really see how there can be two points of view about this. For example, the issue has arisen in several communities about whether life coaches can be collaborative divorce coaches. There's another issue, which I'll talk about later, which has to do with various models for delivering mental health coaching services. That's a different question. But can life coaches do that? Well, no, they can't do that. They can do something else. They can do what they've been taught to do. But if you look at our standard for what a collaborative divorce coach is, you've got to have a whole lot of very sophisticated training about family systems, family dynamics, child development, grief and recovery process from a psychodynamic sense. Life coaches don't get trained in those things. They get trained in something else, which is a good thing to have training in. And many fully credentialed collaborative divorce coaches also get training in life coaching because it's a valuable skill. But if you were getting a divorce, I don't think you'd want to entrust, or let's say if you had a child who was getting a divorce, you wouldn't want to entrust the family system's health to someone who had no training in the psychodynamics of family systems going through divorce. Life coaches don't get that as life coaches. Some individuals may have additional training in those areas, but the way that you demonstrate how much training you've had is by getting credentialed. Now, having said that, I have referred clients of mine to life coaches for life coaching. That's not the same thing as what we mean by collaborative divorce team practice that integrates collaborative divorce coaching. It's a specific thing. And that's really a theme that I want to emphasize a lot. As collaborative practice becomes mainstream, and now, this year really, for the first time, we're way above the horizon. We were talking to ourselves, mainly, until about 2007. But with the effort that's now coming to fruition of developing a uniform model collaborative statute, our work is attracting a lot of attention from people who are not us, from people who are in the broader legal community, in the academic community, in the public policy community, domestic violence advocates. We're up there and out there. And our work and the quality of our work and the premises of it are being looked at by people who are not inherently sympathetic to it, some of whom are skeptical of it or even downright suspicious of it. And one of the lovely things about our movement so far has been the single voice with which we've been able to speak and to encompass diversity within a really uniform consensus about best practices, standards, ethics, all of those things that are such important protections for clients who are embarking on a different way of doing divorce. So now we're above the horizon, and very appropriately, those who express concerns or questions about our work are focusing on fully informed choice. That's just what they should be looking at. And even if they weren't looking at it, it's really the theme that you hear again and again when debates pop up on the collaborative listserv about ways of practice or ways of thinking about practice that blur distinctions, that make it more that would, if adopted, make it more difficult for clients to understand exactly what it is we're offering them and what we're not offering them. And so far, here we are in pulling toward the end of 2008 as I'm talking, so far we haven't seen one reported appellate decision faulting collaborative lawyers in any way. I think there was one malpractice action that had to do with other aspects of the divorce that weren't the collaborative practice aspect of it. But the reason I think why practicing in family law, which is one of the specialties that's most likely to result in malpractice litigation for reasons that are obvious if you think about it, mostly people come out of it unhappy. Not in our cases, but in conventional divorce work. Everybody comes out more or less unhappy.